So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay?
Be right back there. She's going to read it again, okay?
Okay. What happened?
On January 10, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
So, Your Honor, in this case, to read the full dim, it was a disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
You know about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with...
Right off the bat, we're seeing Judge Fleischer laying out the stakes, jail time, fines, and that all-important term, probable cause. This is where every courtroom story either crumbles or continues, so keep your ears open.
interference with a public servant. That doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, "I'm the police, stop." We don't live in that kind of society. "I'm the police, I need to investigate you, so therefore stop," all day long. "I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter," all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to
Yes, go ahead.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred to determine,
He's leaving.
He's walking
He's leaving, right? It's like, here, let me come and mess with you more,
That would only,
right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave. Which it wouldn't be, it wouldn't undercut their ability to investigate what they observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass.
Here comes the defense swinging hard. Notice how the lawyer dismantles the police reasoning. He's saying emotion isn't interference and walking away isn't a crime. It's a powerful argument for personal freedom versus police control.
Thank you.
Unless you act like that.
Mr. Ladon, you were on bond for a terroristic threat. You've now picked up a criminal mischief. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas. Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate accusing him of breaking a window at her apartment.
Well, hold, you're going really fast.
Yes, Judge.
The defendant,
Called the officer.
okay,
And he said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment and that the complainant came out the back door to her apartment, but then he changed the story saying that she came out the front door to her apartment to confront him. The defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
the only thing, my concern is who broke the window? Did he break the window?
And Your Honor, so according to the DM's, what the complainant says is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. And she repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have the two further, the complainant said that he was approximately 20 feet away from the back door when she saw him, and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
Boom. The judge rules no probable cause. That's a massive win for the defense. But don't miss the subtle warning. Judges often remind defendants that one wrong move could flip their luck next time. Freedom comes with responsibility.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know? It's,
To be honest, just what we have is that the window was broken, and then she saw him outside at the time when she came downstairs to check on it. That's what we have.
I get it. I get it. I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Okay. Ask that fees be waived. Okay. I'll add.
How far do they live from each other, Alex? You know?
Do you have the same complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house, but he told officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle, and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat, and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if, in fact, you can prove that he has a weapon.
Yeah, Judge.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And
Now the focus shifts, new defendant, new chaos. Judge Fleischer isn't taking chances anymore. The tone shifts from empathy to enforcement, ankle monitor, distance orders, and a firm stand on safety. Total contrast to the earlier case.
I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You were ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask, Judge, that we reset for more than Monday, only because this case is new enough that there's literally no offense report, so I don't know officers' names or...
Case.
So the new case, the criminal mischief, which will be the allegation for the motion for...
Find no probable cause in a criminal mischief.
Well, but the problem is, Your Honor, is that it's on the criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So they can review it. And
So the allegation is, and it's we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both saw a knife. And so
Well,
that's why.
I don't know
So,
if
I
anybody
mean,
did.
I guess I'll give you a full week. You know, that should be sufficient for you to get an OR,
Yes,
get in
yes,
contact
yes,
with both
yes.
witnesses.
just to clarify for both parties here, the officer is the one that said when he contacted him, he found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it. So that today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.